Our topic for today is the principle of generality in criminal law. The principle of generality is actually one of the characteristics of a penal law. In a nutshell, generality refers to the persons or individuals covered by our penal laws. Territoriality, on the other hand, refers to the place where our penal laws are to be applied. And prospectivity refers to the time when our penal laws should be applied. The principles of territoriality and prospectivity will be treated in separate videos. For now, I shall concentrate with the principle of generality. Now, the generality of a penal law simply means that Philippine penal laws are binding on all persons or individuals who reside or sojourn in the Philippines or within Philippine territory. By the way, the term sojourn means temporary stay. It doesn't matter, therefore, if you are a citizen or a foreigner. It doesn't matter if you are male or female. It doesn't matter if you are rich or poor. It doesn't matter if you are a lesbian or a homosexual or whatever gender preference you have, or whatever race or tribe you belong to, or whatever religion you are practicing, or whatever creed you believe in. So long as you are within Philippine territory, you are subject to the application of the country's penal laws. That is basically what the principle of generality is. So long as that person is within the Philippines or within Philippine territory, that person is not exempted from the application of the country's penal laws. For example, X is an American citizen. While visiting as a tourist in the Philippines, X bought a caliber .45 pistol from Y in order that he could defend himself from robbers. Subsequently, he was arrested for illegal possession of firearms. He now questions his arrest as he believes it is his constitutional right as an American citizen to carry and bear arms without need of a license. Is his contention correct? What do you think is the answer here? The answer is no. Under the principle of generality, Philippine criminal laws are binding to all those who reside or sojourn in the Philippines. X is not exempt from criminal liability just because he is an American citizen. Take note of this. The Philippines, being a sovereign or independent state, has a right to uphold its law and punish persons, be they citizens or foreigners, for crimes committed within its territory. Question: what is the legal basis for this principle of generality? The legal basis is found in Article 14 of the new Civil Code, which states, and I quote, "Penal laws and those of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations." Another legal basis is Article 3, Section 1 of the 1987 Constitution, which states that no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. The word person in Article 3, Section 1 does not only refer to Filipino citizens, it refers to foreigners as well. While the Philippines has the right to require compliance with its laws and punish foreigners for crimes committed within its territory, they, or meaning these foreigners, are also entitled to our protection while they reside or sojourn within Philippine territory. Thus, a foreigner also has the right to due process. What is due process? Due process is the right of any person to be heard before any judgment is made against him for an act or omission defined and punished by law. For example, X, an Afghan national, was arrested by the police and detained without trial based merely on Y's accusation that X is a terrorist. Is there due process here? The answer is no, there was no due process. Why? Because the arrest and detention of X without judicial trial is a clear violation of the said right. A foreigner also has the right to equal protection of the laws. What is equal protection of the laws? It is basically a guarantee that all persons who are similarly situated shall be treated alike both as to privileges conferred and liabilities enforced. For example, X, a Mexican, and Y, an American, both have expired visas. They are therefore both considered overstaying foreigners. Now, if only Mexicans like X are summarily deported while Americans like Y are not, then this violates the right of X and those Mexicans to equal protection of the laws, since foreigners should be treated alike as to liabilities enforced. In this example, summary deportation proceedings are governed by Memorandum Circular Number SBM-2015-010, otherwise known as Bureau of Immigration Omnibus Rules of Procedure of 2015, which became effective on November 9 of that same year. Question: are there instances where our penal laws do not apply, even if a crime is committed by a person residing or sojourning in the Philippines? The answer is yes. These instances are found in treaties or treaty stipulations. They are also found in laws of preferential application and by virtue of the principles of public international law. Let's deal with each of these instances in this and in the succeeding slides. First, let us discuss treaties or treaty stipulations. An example of this is the RP-US Visiting Forces Agreement or VFA, ratified by President Estrada on October 5, 1998 and concurred in by the Senate on May 27, 1999. The question here is, what is the rule in the event a U.S. military personnel commits a crime while in the Philippines pursuant to the VFA? A distinction must be made such that U.S. authorities have jurisdiction with respect to, number one, offenses committed by U.S. military personnel against the property or security of the United States, or offenses solely against the property or person of U.S. personnel. Or number two, U.S. authorities have jurisdiction with respect to offenses arising out of any act or omission done in the performance of official duty. Let us go through some examples or instances when U.S. authorities have jurisdiction with respect to offenses committed by a U.S. military personnel while in the Philippines. First instance is when a U.S. military personnel commits an offense against the property of the United States while in the Philippines. For example, X, a U.S. serviceman, stole several firearms placed inside the U.S. military plane while that plane was stationed in the Philippines and sold the same to his Filipino friend Y. This is a clear example of an offense committed by a U.S. personnel against the property of the United States. In this instance, it is the U.S. that has jurisdiction over the offense and not the Philippines. Another instance where U.S. authorities have jurisdiction is with respect to offenses committed by U.S. military personnel against the security of the United States. When I say security of the United States, it refers to offenses relating to security like treason, sabotage, espionage, or violation of any law relating to national defense. For example, X, a U.S. soldier, being in possession of data or information relative to the defense of the United States, discloses their contents to a representative of another nation, like for example, Russia. In this instance, it is not the Philippines that has jurisdiction over the offense committed by the said U.S. military personnel, but it is the U.S. authorities that has jurisdiction over the offense committed by X in this example. Another instance is when the offense committed by a U.S. military personnel is an offense solely against the property of another U.S. personnel. For example, X, a U.S. soldier, stole the cell phone of Y, also a U.S. serviceman. So, yung Amerikano na sundalo, kinuha niya o ninakaw niya yung cellphone ng kabaro niya, who is also a U.S. serviceman. That is a clear case of theft, but because of the visiting forces agreement, it was agreed by the two nations, the Philippines and the U.S., that jurisdiction over this kind of offense is with the U.S. authorities and not with the Philippine authorities. Another instance is when the offense committed by a U.S. military personnel is solely against the person of another U.S. military personnel. For example, X, a U.S. soldier, murdered Y, also a U.S. soldier. And last but not the least, U.S. authorities have jurisdiction with respect to offenses arising out of any act or omission done in performance of official duty. For example, X, a U.S. soldier, shot Y, a Filipino scavenger, who attempted to force his way inside the military camp even after being ordered to stop. So, here, X, the U.S. soldier, had a duty to prevent Y from going inside their military camp. But X here in this example used excessive force, which led to the death of Y. Now, this is a clear example of an offense committed by a U.S. military personnel arising out of any act done in the performance of his official duty. It is not the Philippines that has jurisdiction over this kind of offense, but it is the U.S. authorities. On the other hand, Philippine authorities have jurisdiction over U.S. personnel with respect to other crimes or offenses, meaning those crimes or offenses not under the jurisdiction of U.S. authorities, such that Philippine authorities can impose sanctions and punishments against erring U.S. military personnel in accordance with Philippine laws. For example, X, a U.S. Marine, killed Y, a Filipino transgender, after he found out that the latter was gay. Here, the jurisdiction is with Philippine authorities because the crime committed by X is a crime committed against the person of a private individual. It is not among the offenses subject to the jurisdiction of U.S. authorities. However, the custody of X pursuant to the VFA shall immediately reside with U.S. military authorities if they so request from the commission of the offense until completion of all judicial proceedings. What this means is that the detention of X, even if the crime committed by X is subject to the jurisdiction of the Philippines, X will not be detained in a jail or detention facility managed by Philippine authorities. X will be detained in a facility managed by or operated by U.S. authorities. If the U.S. authorities so request that X, their erring military personnel, be confined in the said facility, and moreover, in case of conviction, X shall be confined in facilities agreed upon by appropriate Philippine and U.S. authorities. So, posible na, in case makonvict si X dito, sa case na to, he will not be detained or confined in the New Bilibid prisons, a detention facility, a jail managed and operated by the Bureau of Corrections, because the VFA provides that such detention facility for purposes of service of sentence by the convicted U.S. military personnel will be done in a facility to be agreed upon by Philippine and U.S. authorities. Now, another instance where Philippine penal laws do not apply even if a crime is committed by a person residing or sojourning within Philippine territory is with respect to laws of preferential application. For example, Republic Act number 75. This law prohibits the prosecution, arrest, and detention of ambassadors or public ministers of any state, provided they have been authorized and received as such by the President of the Philippines, and any domestic or domestic servant of any such ambassador or public minister, provided the name of that servant has, before such prosecution, been registered in the Department of Foreign Affairs and transmitted by the Secretary of Foreign Affairs to the Chief of Police of the City of Manila, who shall, upon receipt thereof, post the same in some public place in his office. Now, the word or the term ambassador means he is the what? Official envoy who represents a state and is accredited to another sovereign state as the resident representative of their own government or sovereign. The term ambassadors and other public ministers comprehends all officers having diplomatic functions, whatever their title or designation may be. On the other hand, a domestic is a person residing together with the ambassador, like a family member or any member of the ambassador's household, like a driver. A domestic servant, on the other hand, is a person who performs work in a private household. So please take note of the definitions of the said terms, no? Ambassadors, public ministers, domestics, and domestic servants. Example, X, the driver of the US ambassador to the Philippines, drove the embassy-issued car in a reckless manner. As a result, he hit and bumped Y, who died thereafter. Question, can X be charged and prosecuted for the death of Y? The answer is no. Under Republic Act 75, X is entitled to the immunity enjoyed by the said ambassador. Take note, however, that this grant of immunity is reciprocal. Republic Act 75 applies only when the country of the diplomatic representative has provided for similar protection to duly accredited diplomatic representatives of the Philippines. The third and last instance where a person is not subject to the operation or application of our penal laws, even if such person commits a crime in the Philippines, can be found in the principles of public international law. Now, the following persons which I will be enumerating in this slide are not subject, to repeat, to the operation of our penal laws, meaning to say, they cannot be prosecuted, they cannot be arrested, and they cannot be detained even if they commit a crime in the Philippines. They are therefore immune from criminal prosecution. Who are these persons? They refer to, or they are the sovereigns and heads of state, and the ambassadors or ministers plenipotentiary, ministers resident, and the charges d'affaires. When you say minister plenipotentiary, he is a diplomatic agent ranking below an ambassador but still possessing full power and authority as a diplomatic agent. A minister resident, on the other hand, is a diplomatic agent who is a resident at a foreign court or seat of government and ranking below a minister plenipotentiary. And a charges d'affaires is a diplomatic official who temporarily takes the place of an ambassador. He is a diplomat who serves as an embassy's chief of mission in the absence or unavailability of the ambassador. Question: what are consuls? Is there a difference between a consul and an ambassador? An ambassador is the foreign diplomatic representative of a nation who is authorized to handle political negotiations between his or her country and the country where the ambassador has been assigned. On the other hand, a consul is the commercial agent of a nation who is empowered only to engage in business transactions and not political matters in the country where he or she is stationed. Follow-up question: are consuls entitled to the privileges and immunities of ambassadors? What do you think is the answer here? The answer is no. Consuls are not exempt from criminal prosecution. For example, X, a German consul stationed in the Philippines, shot and killed Y after a traffic altercation. Can X here be charged and prosecuted for homicide? The answer is yes. Why? Because X is merely a consul, and as such consul, he does not have immunity from criminal prosecution.